SJC-12201, George Modica v. Stephen W. Tompkins, and others.
Good morning still, Mr. Winkler.
Good morning. Excuse me, if it may please the court. My name is Noah Winkler. I'm the attorney for the plaintiff appellant, George Modica. This case is about assault pay benefits, which are benefits that supplement workers' compensation benefits. We had filed a claim for these benefits, and the claim was denied. A lawsuit was filed. The sole issue in the case is a legal issue, whether Mr. Modica suffered a bodily injury within the meaning of the assault pay statutes. Cross motions for summary judgments were filed in the Superior Court. The plaintiff's motion was denied. The defendant's motion was granted. We lodged an appeal, and this court took it up sua sponte, and that brings us here today. I have two arguments that I'm going to give you today. The first one is that what happened to Mr. Modica is a bodily injury, even if we interpret bodily injury as the Superior Court did. But the second argument is that we should be interpreting bodily injury the same way that personal injury is interpreted in the workers' compensation statute. So even if this court were to find that Mr. Modica did not suffer a bodily injury as the Superior Court interpreted the term, nevertheless, this case is still compensable under the assault pay statute. In the defendant appellee's brief, they note that one of the definitions of bodily injury in a number of statutes, including Mass General Laws Chapter 265, Section 13J, is that bodily injury equals substantial impairment of the physical condition. And if you look at what happened to Mr. Modica in this case, I think certainly what happened to him was a substantial impairment of his heart, and therefore it constitutes a bodily injury.
Counsel, isn't it fair to say that tachycardia is more of a, refers to heart function as opposed to the condition of the heart?
I would agree with that, but there's nothing saying that an impairment of functioning cannot constitute an injury. And if we look at some other examples, for example, if someone suffers a muscle cramp, over time their muscle will be back to normal and there's no structural damage. But nevertheless, that would constitute a bodily injury. There's similar, something like a bruise would be an injury, but it would have no lasting structural damage.
But you're really asking us to define bodily injury there as it relates to tachycardia differently than two cardiologists did. I mean, there's an appeal to your argument. Somebody's heart's pacing all the time, and pacing fast all the time. I can see the argument that that would be a bodily injury, but we have two cardiologists who have said it isn't, and you're asking us to come up with a different physiological determination than two cardiologists.
Well, I think what the law we're interpreting is different than what we're saying. So the cardiologists are saying there's no long-term structural damage to his heart, which I agree with. The cardiologists are also saying that this isn't necessarily a disease of his heart. It's a physiological reaction. But nevertheless, when we look at what that physiological reaction is, it's a very rapidly beating heart that makes him lightheaded, dizzy, faint. He's unable to basically function at that time. So there's a substantial impairment in his functioning, so that while they may be saying that's not a cardiac disease, there's no long-term structural damage, I think we can still say that that's substantial impairment of the physical function such that it's covered under the assault pay statutes. I think it's also important that we look at some of the case law on assault pay statutes with the other elements. So there's a number of different elements to establish to be entitled to the statutory benefit. We're just talking about bodily injury today, but there's an in-custody requirement, so the prisoner that injures you has to be in your custody. That was found to be met when a guard was running towards the fight and was nowhere near the fight.
I don't think the other side contests any part of that.
No, but I'm saying when the court has interpreted the in-custody requirement, they did that very broadly.
Right.
So then when we're doing bodily injury, we should similarly do it as broadly as we can within the ordinary meaning of the words, such that,
That means, say, if you had stress-induced obesity based on, your work, that would be a bodily injury?
well, I think that's a little different because obesity is just a general condition. Here we're talking about an impairment to the organ, the heart.
Well,
I mean, I guess if your
You'd have
obesity,
high blood pressure, right? And you'd put stress on your joints.
if you could make the causal connection and there was enough of an impairment to your function, I guess under this this reasoning that would apply. But I think it would be hard to causally connect obesity to work. But along with what you're saying, there's 4 types of injuries. There's a purely physical injury. There's a physical injury that leads to then an emotional reaction. There's an emotional reaction that leads to, or a non-physical injury that has a physical component, which is what I'm saying this case fits into. And then there's a 4th line of cases, and that's a non-physical injury resulting in an emotional, a non-physical injury. So that's what the defendant appellees are asserting that this case falls into. And they're pointing to, and the Superior Court judge relied a lot upon the fact that, well, they used the term bodily. They didn't use personal injury. So they wanted it to be one and the same with workers' compensation, then they should have used the word personal, and that's a knowing and deliberate choice. But if you actually look at the case law and the timing, that was not, in fact, the case. Because a non-physical injury leading to an emotional injury, so a PTSD or something like that where you're never physically injured, that did not become compensable under the Workers' Compensation Act until Fitzgibbon's case by this court in 1977.
Can you explain to me how we're supposed to consider the different words that were used in the statute? Personal injury being more broadly interpreted, bodily injury having another kind of definition.
Sure.
So what could we say to support a finding that they mean the same thing?
Well, my response to that is, as far as I can tell, the assault pay statute, first version was enacted in 1951. And at that time that was enacted, bodily injury and personal injury, there was no distinction because what was compensable under the Workers' Compensation Act at that time were physical injuries, that's a bodily injury, physical injury that leads to an emotional injury, still obviously have a bodily injury, or an emotional, stress causing a heart attack, where again, you very clearly have a bodily injury. So at that point in time when the assault pay was enacted, everything that was compensable under the Workers' Compensation Act would also be considered a bodily injury. So those terms would have meant the same thing. So there was the first example that I found of any emotional distress case without a physical injury being compensable was in 1977, so some 26 years after. So we can't say the legislature intended to guard against those types of injuries when those weren't even considered within the realm of Chapter 152, the Workers' Compensation Act, at the time this statute was first enacted. I think the purpose of this statute is that corrections officers, trial court officers, you're involved with very violent people, and there's a risk of harm to you from altercations. So we want to make sure that when someone is injured, we cover them to the extent possible. I think that's why the court has interpreted, the appeals court and this court has interpreted some of the elements of the claim broadly in the past. And so that's why I think the statute was intended to, if you're entitled to workers' compensation as a result of a fight, then you're entitled to these benefits too. In the use of the word bodily, I don't think that was of any significance, because legally at that point in time, everything that was covered under Workers' Compensation Act would still be considered a bodily injury. So we know from prior case law that you don't need to actually be physically struck by the inmate. You can be running to them. So I think I would say if Mr. Modica had suffered a heart attack from the same situation, we would agree that he suffered a bodily injury. So here he didn't suffer a heart attack. He suffered something less. So what you're asked to do, well, what he suffered was that substantial impairment of his condition. And I think it was considered to be disabled in contested workers' compensation litigation. He started taking beta blockers, a new medicine specifically aimed at the functioning of his heart to help it in these situations. He had to stop his job as a corrections officer because he was no longer able to respond to these situations adequately. He just was overcome by his heartbeat and the physiological response. So I think that's definitely a substantial impairment. And so I think the focus below was too much on the fact that it was an intentional distinction. But even if we ignore that, there's no case law to support that a temporary loss of function is not an injury. In some of the other examples, clearly we would say, a muscle cramp or other things, those are injuries. So we don't need to have permanent structural damage.
But pragmatically, if you prevail, won't that mean that any time somebody claims PTSD and gets workers' comp because of PTSD, that they're going to get bodily injury?
Well, first it would have to be as a result of an inmate,
Right, of course.
altercation, and so you'd have to say specifically as a result of that. But I don't think we have to get there, because this isn't like the Leiden case, the other Superior Court case. There's no diagnosis of post-traumatic stress disorder. There's no psychological diagnosis.
Right, I know that's not here, but I mean,
But I
taking
guess,
Justice
yes,
Bud's
under
point,
this logic, if,
PTSD is going to have physical manifestations. When you're having it, you're going to have changes in blood pressure and heart rate and other physical manifestations, and it sounds like you're saying that is sufficient.
I think so, because I think, again, I think the intent was to say that any kind of workers' compensation situation arising out of an inmate altercation, if all the elements are met, then you should get workers' compensation. And the use of the term bodily versus personal there was no intention there to narrow the types of cases.
Well, the legislature did it in the context of insurance law.
Well, different words can have different meanings in different contexts. So
in this situation, is there anything that separates an assault, a workers' compensation claim from the assault statute? So what I think I hear you saying is that if someone in the context of altercation is injured and they get workers' compensation, it then follows that they get assault pay.
Well, that's one of the things that I'm putting forth to you today, but I think even if you reject that argument, I still think this case comes within a bodily injury, because the injury to his heart was enough of a substantial impairment that you don't have to reach the question of personal versus bodily. You can say even under bodily, this is close enough to a heart attack type situation.
Question or a legal question? Is that a medical interpretation or a legal interpretation?
Well, it's a legal interpretation of the medical evidence, I think. There's other cases, for example, in criminal law, where the fact finder determines if there was substantial bodily injury, and there's statutes on what's a substantial bodily injury. So here, what the fact finder, in this case, what you're asked to decide is what happened to his heart, would that be considered substantial impairment? And if you look at new medications, effect to his job, and to me it's like you might have a knee injury and you could do everything, but as soon as you do one specific activity, you're not able to do it. And that's what the case is with his heart. So I think the trial judge minimized his condition unfairly. It's not just, oh, a racing heart and it's no big deal. This is basically paralyzes him at the time it happened. It made him switch careers. They prescribed medications for him. And it was found that this is a condition that existed specifically as a result of these inmate altercations.
Okay, thank you.
Thank you.
Mr. Forbes, good morning.
Good morning. May it please the court. My name is Alan Forbes. I represent Suffolk County Sheriff Steve Tompkins and the Suffolk County Sheriff's Department. This case presents a straightforward question for this court to resolve: whether a person who claims bodily injury under the assault pay statutes has to prove physical damage to some portion of his body. The Superior Court judge was faced with uncontroverted medical evidence that there was no physical injury to Officer Modica, and he was therefore not entitled to recover assault pay benefits.
May I ask you a preliminary question? If you assume that the purpose of the statute is to make sure that people who are injured doing their duty and they're hurt by inmates, why would the legislature make a distinction between people who got bodily injury and any other kind of injury if the purpose is to compensate when that happens? The statute is focusing on how the person got hurt, not necessarily what the harm was.
Well, the statute does focus on what type of harm is involved. The statute was not, by its language or by its history, there's no evidence that it was intended to create universal coverage for any correction officer injured by inmate violence.
So it makes sense to distinguish among the class of corrections officers who are hurt in encounters with inmates.
The legislature did exactly that when it amended the assault pay statute in 1977. The county statute in its original form applied without limitation to the type of injury. It said that the county will indemnify the officer for damages sustained by the officer as a result of the willful act of an inmate because of temporary incapacity caused by injury without restriction. So that's the state of play in 1955 when the assault pay statute on the county level is enacted. Then we jump forward to 1977. The legislature amended the statute to its current form and added the restrictive modifying term bodily before injury. I would agree with my brother's argument if the legislature didn't modify or restrict the term injury. But it's clear as we look at these two versions of the county assault pay statute that the legislature intended to draw a line on what sorts of injuries would be compensable for this very special benefit. So for the court to hold for Mr. Modica in this case would really be to obliterate the distinction between personal injury and bodily injury that exists in both in workers' compensation law and in other areas of law of this Commonwealth.
And what do you say to his argument that in 1977, they were at a different place in terms of the scope of workers' comp injury, and they didn't really think that this would have this consequence?
That, conceding for argument at that point that personal injury wasn't thought of in the same way in 1977, we can look to the fact that the state assault pay statute was amended in 1998 and again in 2016, and both times the legislature saw fit to leave undisturbed the restriction of bodily injury for compensable injuries under this statute. In 1998, rather in 2016, the legislature extended assault pay benefits to court officers. But again, the analysis was limited to bodily injury and because of an escaping prisoner. So it's certainly, they're tinkering with the statute at that point on the state level, and they're well aware of the notion of personal injury as my brother has described it to the court today.
So to the extent that the plaintiffs would concede that personal injury is different than bodily injury, what do you say to the argument that we should look at this situation and say it falls within the definition of bodily injury.
In order to do that, the word bodily stops meaning anything. It becomes personal injury at that point. The evidence before this court, the only evidence before the Superior Court was that Officer Modica had no physical injuries. Both of the doctors who examined him in the work comp proceedings had that in their reports. The administrative tribunal adopted those findings. There were no physical injuries. And the record also in both tribunals was that this diagnosis of sinus tachycardia just means that his heart was going fast. Dr. Hartley, who was one of the impartials in the work comp proceeding, testified at a deposition, and he explained what was meant by sinus tachycardia. And he said that it was a function of Mr. Modica being emotionally upset at the time. His heart rate responded fast, and it is a perfectly normal response. It's adrenaline release from the body. He goes on to say that sinus tachycardia just means that his heart is going fast. It's not a cardiac diagnosis. There is no damage to Officer Modica's tissue, his bones, none of that. This is a psychological injury that he has. And while it has physical manifestations, that doesn't change the cause of the injury. The cause of the injury here is a psychological reaction to the stress that Officer Modica experienced when he was wrangling with inmates in the jail. And that's through and through in the record. Both of the doctors, and indeed the only medical evidence before the Superior Court, was that this was an emotional response to stress. Not that it's not real, not that it's not troubling to Officer Modica, but it is not a bodily injury.
So if he had had a heart attack, triggered in some fashion by the tachycardia or by other stress-related consequences, that's bodily injury?
If a doctor testifies that that heart attack was caused by this incident and supplies that causal connection, now we're in the realm of damage to tissue rather than change in function. All we have with Officer Modica's heart is it's functioning in a slightly different way. It's going faster than it normally does. But the only evidence in the Superior Court was that is not a harmful condition.
So a heart attack is in, stroke is in, because it's damage to tissue.
If a physician provides the causal connection.
Right. Causal connection. If one says that this incident caused PTSD and the PTSD created physical manifestations which led to this, that would be sufficient.
If you get there to the point that the body tissue itself is damaged and altered, then you have a bodily injury. But we're not there yet. All we have is symptoms consistent with an anxiety disorder, according to the reviewing board at the DIA.
One of your points is that, well, as it relates to the nature of the injury, we're limited to the record below.
Absolutely.
As opposed to whether none of us are cardiologists, believe that this is a bodily injury.
That's correct. The only evidence in this record is that Officer Modica had no physical injuries. So to find that he somehow has a bodily injury within the meaning of that statute would require the court to ignore that limiting term bodily.
So high blood pressure would not fall within the bodily injury under your analysis?
I beg your pardon?
A high blood pressure would not fall within your analysis?
It would not.
And this would be akin to that. Tachycardia would be within the realm of high blood pressure, and that it's a functioning of the system, but not damage to tissue.
That's the way his body is behaving in that moment. That in itself, because it's something other than he would like it to be, does not mean
what's
that
the policy behind that, to say that if you have a heart attack, okay, but if you have high blood pressure, no? What sense does that make if the purpose of the statute is to compensate people who get hurt in that particular situation? Why would they distinguish between the two?
Because the purpose of the statute is apparent on the face of its language. It is to compensate people with bodily injuries caused by violent prisoners. And that's just not what happened here. The legislature drew a line there because, for whatever reason, they didn't want to compensate all injuries. There's nothing in the legislative history or in the record that explains why they chose to impose that line. But that's the language in the statute. And in order to give meaning to that term bodily, injuries like Mr. Modica's must be excluded.
Well, if you think of the statute as adding something to Chapter 152, workers' compensation. And that's the main purpose of it. It wouldn't make any sense to draw distinctions between emotional injuries and physical injuries. And I'm not really sure that tachycardia is just emotional. I mean, it's a physical thing that's happening to somebody.
It certainly, as I would concede, it is a physical manifestation of a psychiatric or mental condition, but it itself is not a physical injury. And the workers' compensation statute deals with mental and psychological injuries. It calls them personal injuries in Section 17A of Chapter 152. That statute is referred to by the assault pay statute, and presumably the two statutes ought to work together. So
Yeah, well, that's my point, that one interpretation could be, okay, obviously this person is hurt on the job, he's going to get workers' compensation. But because of the nature of the job that the person is doing and the nature of the source of the harm, we're going to make sure that he doesn't suffer any loss of income because of this. We want to do more for folks who get hurt in those kinds of situations. I just can't imagine, I'm having difficulty trying to understand why, if that's what the legislature wanted to do, is to tax something on the workers' comp, why they would say that employee X is not entitled to it, but employee Y is. And bodily injury doesn't answer that for me.
Well,
it doesn't explain it.
we can look then to the language of Section 17A of Chapter 152 that treats mental and emotional injuries with a more skeptical eye than bodily injuries. A claimant who's seeking to recover work comp for a mental injury has to show that that mental injury is the predominant cause of his disability, and that's a higher standard than that imposed on bodily injury. So while we can't know exactly why the legislature chose to use the term bodily injury in both of these statutes, we do know that the legislature treats mental, psychological type injuries and bodily injuries different. I'd also refer the court to Section 6D of Chapter 231. That's the tort eligibility statute for motor vehicle accidents. And the statute says in sum that while you can sue for bodily injury without treating up to the amount of $2,000, if you want to get mental suffering damages, you have to meet the tort threshold of $2,000. So there is some sense in the legislature that there's something qualitatively different in the way they're going to draw their lines between bodily injuries and mental injuries. And so we can assume that that the legislature intended to use the term bodily injury.
Thank you. We'll take
Thank
our
you.
morning break.
All rise.